In March 2026, the tech industry hit a legal brick wall. Mark Zuckerberg took the stand in front of a jury for the first time. Days later, a Los Angeles jury ordered Meta and YouTube to pay $3 million to a single plaintiff, while a court in New Mexico hit Meta with a separate $375 million penalty. Meanwhile, TikTok and Snapchat avoided the courtroom altogether. They quietly settled their own claims just days before their trials were scheduled to begin. So the first time, courts are holding tech giants liable for the psychological damage their applications cause to users. These verdicts removed a decades-old layer of legal protection. Social media companies can no longer operate without the looming threat of massive financial and legal consequences. For nearly 30 years, whenever a social media platform was sued over cyberbullying, eating disorders, or harmful viral trends, the platform almost always won in court. Their primary defense was a piece of legislation signed in 1996 called Section 230 of the Communications Decency Act. Section 230 is a federal law that protects internet companies from liability for the material that third parties post on their websites. Under this law, tech companies successfully argued they were merely neutral bulletin boards. If a user posted something dangerous or defamatory, the user was at fault, not the digital corkboard hosting the message. Given that Section 230 makes these platforms legally bulletproof against user content, plaintiffs had to find an entirely different way to win hundreds of millions of dollars in 2026. The Los Angeles Superior Court served as the testing ground for this shift, specifically during the landmark KGM trial. Lawyers moved the argument away from the harmful videos and photos their client viewed. They focused instead on the software engineering that delivered them. They applied the framework of product liability. In the physical world, if a car has failing brakes or a toy has lead paint, the manufacturer is strictly responsible for selling a defective product. Classifying a social media app as a defective product bypasses the Section 230 shield. This approach focuses on the engineering of the interface rather than the speech of the users. The mechanical logic of infinite scroll continuously loads new content without friction, eliminating natural stopping cues. By randomizing push notifications, the app hijacks psychology just like a casino slot machine, creating intense dopamine spikes. Through expert testimony and leaked internal documents, the jury saw that platforms knew these features caused anxiety and body dysmorphia in developing adolescent brains. The jury ultimately found that the companies prioritized engagement metrics and advertising profit over mitigating these known neurological risks. Because the tech companies engineered and deployed these addictive dopamine loops themselves, they were found directly liable for the resulting psychological harm to the plaintiff. The KGM and New Mexico cases were specifically selected as bellwether trials. A bellwether trial is a test case used in mass civil litigation to see how a jury will react to a specific legal argument before lawyers try thousands of similar lawsuits. With the juries accepting the design defect argument and awarding millions in damages, the blueprint is now validated for thousands of other lawyers to use. This triggers a massive legal movement gathering in California federal court, known as MDL 3047. MDL stands for Multi-District Litigation, a legal procedure that groups together hundreds or thousands of related cases to speed up the process. This map visualizes the immense scale of MDL 3047. It groups together over 10,000 individual personal injury cases, lawsuits from 41 state attorneys general, and claims from nearly 800 school districts demanding economic compensation for counseling and support services. Proving the legal strategy in one Los Angeles courtroom provides a tested roadmap for thousands of other claims, creating a nationwide financial threat to the tech industry. Legal experts are directly comparing this moment to the massive settlements that brought down the big tobacco empire in the 1990s, when executives were forced to answer for concealing the addictive nature of their products. They are also pointing to the opioid crisis litigation of the 2010s, where corporations were held accountable for downplaying known product harms to the public. Social media platforms can no longer defend themselves by claiming to be passive, neutral spaces for free speech. The courts are focusing strictly on the mechanical design of the software. Tech companies now face a choice: absorb massive industry-wide financial payouts or completely redesign how their platforms operate.